Okay, we're on Unit 2, which is Real Estate License Law and Qualifications for Licensure. A quick summary of the chapter. The important statute and rules. We need to know that Florida Statute 20 is the executive branch rules, and it is those that authorize the formation of Florida Statute 475 and Florida Statute 455. 475 is the Real Estate Professional Practice Act, and 455 is the DPPR rules and regulations. 475 is divided into 4 parts: Part 1, Part 2, Part 3, and Part 4. Part 1 is to do with brokerages and schools. Part 2 is the rules that determine how appraisers do their job. And Part 3 is the Sales Commission Lien Act, which we'll talk about later. Don't worry about that. And Part 4 is the Leasing Commission Lien Act. Florida Statute 455 governs all the licensed disciplines in Florida, of which real estate is one of them. When we want to know how to implement these rules, then we will look at Florida Statute 120. And then FREC has its own administrative rules under the Florida Administrative Code of 61J2. If you need to know more about the state examination and the syllabus, you need to go to Bob Hoag's website and click on the State Information Booklet, link on the page there. And this is what you'll see. This is a closed book examination at the end of the course, and we'll see the syllabus, the subject areas, and what percentage of each unit pertains to the final exam on the state. We're talking about the 3 categories of real estate licenses. We must understand, first of all, there are only 2 real estate license types, that is sales associate and broker, but there are 3 categories under which you may work. You may work as a sales associate with a sales associate license. You may act as a broker of record or the broker of a brokerage with a full broker's license. Or if you have got a broker's license but you choose not to be a broker of record but work under a broker, then you'll be regarded as a broker associate. Sales associates are employed by and work under the direction and control of a real estate broker or an owner-developer. Sales staff must hold active real estate licenses under an owner-developer if they are paid a commission or compensated on a transactional basis. You do need to put in an application. The application will last for 2 years. You'll pay various fees, and there are fee waivers for low-income applicants and also for the military personnel and their spouses. And fees are waived for military veterans and their spouses who apply for a license within 60 months after honourable discharge. You will have to do your fingerprints. Best to do it 5 days before the application, because these fingerprints go off to the FBI and your record is then handed over, if any, to DPPR, and that will give it a chance to get there before they receive your application. And on your application, basically you must provide full details if you have ever been convicted of a crime anywhere at any time, any country, found guilty and or entered a plea of guilty but all non contendere, or if the court chose not to punish you but put you on probation, or even if your record has been expunged by an attorney, then please go and check that to make sure that it has been expunged. It takes 30 days to check for errors and omissions. They'll give you a notice of sufficiency if anything is missing, and you're informed within 90 days of approval or denial. If denied, the applicant has 21 days to request a hearing, and when the application is complete, you will become eligible to take the exam. Notification is then sent to the testing agency, Pearson VUE, and you can check on DPPR website under your name. Once again, on Bob Hoag website, here is the place where you can go and click to arrange your fingerprints and also to schedule the exam. There is reciprocity for U.S. service members. If you are a U.S. service member or a spouse and you are in Florida and you have an active license from another state, then they will grant you a license. You still have to do your fingerprints and put in the application. Non-resident applicants, you don't have to be a resident or citizen of Florida. You must have a social security number, and resident licensees who become non-residents must notify the Commission within 10 days of your new mailing address, and also then within 60 days of your change of residency outside of Florida. We do have reciprocal correction. We do have mutual recognition agreements with other states. These recognize the education experience that real estate licensees have acquired in another state or nation. This applies to non-residents only. You have to get certification of your license history from that mutually recognized state or nation. You have to pass a 40-question real estate law exam and get 75%, which is 75%, which is 30 correct points. And you still have to do your fingerprints application and pay the fees. And to get this, you have to be a non-resident. A person who has resided in Florida continuously for a period of 4 calendar months or more within a preceding year is regarded as a resident, or from the date you intend to permanently reside in resident. So if you are a Florida resident, you cannot seek a Florida license through mutual recognition. You have to be 18 years or older to put in your application, have a high school diploma or equivalent, and have a social security number to check on your child support obligations. Be honest, competent, and disclose, once again, any convictions and so forth. Any other names that you've had, such as a maiden name. If you have had any disciplinary action taken against you for any professional license anywhere, and also if you have been denied a real estate license anywhere. And the application you put in is good for 2 years from the date of approval. You can take the state exam. Anybody with a criminal history will actually be added to the summary of applicants, and the applications with the criminal history are flagged. They're reviewed monthly at the Florida Real Estate Commission agenda meetings in Orlando. They may have to appear before the FREC to explain your criminal history, and letters of character or person speaking on your behalf can be presented to support your case. This is course 1, which is a sales associate course, so you have to complete this course, and it's 60 hours of instruction plus a 3-hour end of course exam and a passing score of at least 70 on the 100-question multiple choice question exam, and it's closed book. So regulations pertaining to pre-licensed courses. Students failing the end of course exam must wait at least 30 days before taking a different exam, or the student may retake the end of course exam a maximum of 1 time, or retake the entire course in class online. And you may also not miss more than 8 hours of instructional hours, otherwise you will not be allowed to take the final course exam. There are exemptions. If you're a 4-year degree person in real estate, then you're exempt all of the courses, the post-licensing courses, the broker course, and the broker post-licensing course. But you must do, after the initial renewal period, the 14-hour continuing education every 2 years. Everybody must do the state exam. That means a 4-year degree person has to do the sales associate and the broker state exam. If you are an attorney with a Florida bar, then you are exempt just this course, but you have to do all the other educational requirements except for the final 2-year renewal 14-hour continuing educations, because you are a lawyer and you should be up to date with the law. There are time limits. Applicants that do not pass the state license exam within 2 years of their course completion date must retake the course. Exams can be taken in Spanish if requested, and the exam is then given in both languages simultaneously. When you go for your exam at Pearson VUE, you will have to provide 2 forms of ID and a grade report from the class. You will get a 100-question computer multiple choice exam. You have to have 75% to pass, and it can be in English or Spanish, and it is graded at the test site. Post-licensing education. You must complete within the first renewal period a post-licensing course of 45 hours for sales associates. Must pass the end of course exam, and failure to complete this course will cause you to lose your license. You become null and void, and you have to do the course and the state test again. And tips regarding the post-license education: do not enroll until you are licensed, and enroll reasonably soon after becoming licensed, because the course is actually very useful. Do not wait until the last minute in case you fail and you miss your deadline. Then after that, 14 hours of continuing education are required every 2 years for your license period after the initial first renewal. If you wish to become a broker, you have to be an active, or rather a active broker for at least 24 months under a broker within the last 5 years. But this does not account if you are working under a developer. You have to complete a sales associate post-licensing course before you put in your application. You must complete 72 hours of the FREC course number 2 and pass the state exam, which is also 75%. Then after you get your broker's license, you have to do a 60-hour broker post-license course, or gain it under mutual recognition. That is, you have a broker's license in another state which is recognized by Florida as a mutually recognized state. Registration and licensure. Registration is the fact of placing your on record with the DPPR the name and address of each licensed broker, or the name and business and address of sales associate's employer, active or inactive license status, and also if you're involved in a real estate entity as an officer or an owner or developer. Licensure is a record of the licenses held or previously held by individuals. Sales associate and broker associates can only be registered under one broker in Florida, can be licensed as sales associates or brokers or the equivalent in other states with those states' licenses. Here's a typical example of what a license looks like, with an expiry date, a number, and your name and address on it, and there's a little pocket card you can carry. Prima facie evidence. A license is prima facie evidence if ever asked to provide it for inspection. The real estate license is prima facie evidence that indicates that the licensee does actually hold a current and valid license. You do need a license if you perform any of these activities. If you advertise, buy or appraise, rent, sell, auction, lease or exchange, we call it a bar sale. If you perform any of these for somebody else for compensation, then you'll probably need an active license. If you don't, you will be charged with providing services without an active license. Compensation. Anything of value or promise to be paid to an individual for performing any of those services of real estate. That means even if you haven't been paid but you were promised and expecting to be paid, if the transaction went through but it didn't, you're still breaking the law if you don't have an active license. Compensation can only be paid to the broker. You will never ever get paid directly by a client or a customer for services which require a license. All payments must go to the broker, and the broker will then pay you whatever your independent contract agreement states. There are people who are exempt from a real estate license when performing any of those services. For instance, owners of property may buy, sell, exchange or lease their own property for themselves. Individual property owners or officers and directors of corporations and owners of other business entities can also do that. And if you're a partner in a real estate partnership, provided that the partner only receives normal pro rata shares of the profits, and also owners of timeshares. They do not need a license. If you're an attorney at law or a CPA providing normal services, nothing specific to real estate and charging extra for, you don't need a license. And also if you're a state certified or a licensed appraiser when conducting an appraisal, then you do not need a license to perform one of the A's in a bar sale because you have your own appraisal license. But it means they cannot perform any of the other duties without an active real estate license. If you are a salaried employee, you must be paid a salary, not compensated by commission or on a transactional basis of anybody that owns the properties. Those who buy, sell, exchange or lease properties for their business employer, or those who work in an apartment on-site rental office in a leasing capacity, those who are managers of condo and cooperative units who rent units for periods of no longer than 1 year, and if you work for an owner-developer that sell their own property, as long as you do not receive commission. If you are appointed by a court, you do not need a license to be paid. And if you have a power of attorney to sign for a person when in real estate transactions as an attorney, in fact, you do not need a license, but you cannot provide services. There are other miscellaneous exemptions. If you work in a mobile home park or a travel park and rent lots, or if you sell cemetery lots, or you are a registered security dealer selling business enterprises. We talk about that a little bit later. If you're a hotel or motel clerk that rents transient lodging, you don't need a license. Normally you can't pay a finder's fee to someone who isn't licensed, but tenants can be paid a finder's fee up to a maximum of $50 by a manager or an owner of an apartment complex. And a CAM license is required to be paid if you are to be paid to manage 10 plus units or 100,000 in association. That applies to condo associations, HOAs and co-ops. That is the end of chapter 2. Thanks very much for listening, and we'll see you on the next unit. Bye-bye.